I'll turn my microphone on. There's 4 board members out of 5, so we can get a little bit done with the 4 that we have. So calling the general meeting to order. We have a few administrative things to talk about. The first one, let's go the extension request first. This is 2021-087. This is from Justin Williams. He's asking for an extension. This is the first extension, and the reason is in the letter that you have in front of you. Basically, they had some extended community back and forth before they were able to get approval from the Planning Commission, and the Planning Commission just gave them approval on June 9th of this year. This letter is dated August 3rd, 2021, but I think it meant to be dated August 3rd, 2022. So they're asking for an additional 12 months to pull permits and get started. What do you all think about that?
I have no objection.
All right, sounds like a unanimous 12-month extension for the first item. The second item is a reconsideration request. You have kind of 2 diagrams there that I will explain. Hold on just a second. So there's one that's handwritten that says plans approved by BMZA February 2022, and then there's amended plans on the back side. So the board approved an extension with a variance that would be 25 feet deep, if you can see that on the diagram there. And then the applicant went to pull his permits with a set of plans that are 28 feet deep. Do you see the difference there? So the permit office said, hey, you don't have approval for the 28-foot long addition. You have approval for the 25-foot long addition. And so now he's asking us to change or I guess to update the approval that we gave under the reconsideration rule, which requires that the applicant request reconsideration within 10 days of the resolution and give a reason for why they want the reconsideration. That has to do with things like mistake, fraud, mistake, irregularity, inadvertent surprise, or for new evidence that wasn't available at the time of the hearing. So his actual request just said that his client wanted to add 3 feet to the addition and that it doesn't go closer to the property line than what he originally requested, so he thinks he should be able to get that changed without coming back and having a new hearing. So let me know if you have any questions about any of that.
So the applicant didn't come back.
Yeah, you should.
The applicant didn't come back to us to provide new plans, right? After we approved an old plan.
Right. We
They
approved
went-
the 25-foot
Yeah.
addition.
I think it'd be more appropriate, the record would be cleaner, and the permit office would be happier if everything matched up what we reviewed and what was approved. The variance ultimately may not change the one he's seeking, but the record is inconsistent. So I think they need to either submit a new application with the new plan, the way it's supposed to be done, and he doesn't have to wait to do that, right? He can come back and
No, he
file.
could submit a new application today if you wanted to.
Yeah, and we could maybe put him on the next docket, I don't know. But in any event, it wouldn't take a significant amount of time to come back before us with an appropriate plan, so we can consider the variance under those plans and likely, approve it. It's a matter of 3 feet difference. So I would be inclined to deny the motion for reconsideration and have them do what we would expect they would do normally, which is amend your plan, come back to us, we can approve that plan.
I'm fine with that.
Anybody else?
I said I'm fine with that.
Okay.
I'm fine with it as well.
I agree with that as well.
Also fine with me.
Okay, so it sounds like it's a no for reconsideration, but he can certainly reapply under the new set of plans if he wants to.
Right.
Okay, so two more quick things. One is just to let you know, we received a negative appeal, which is 2022-336. This is not scheduled today to be heard, but it will likely be scheduled for the 30th. I'm trying to follow what I found as the board's standard operating procedures. So apparently the standard procedure is that when we get a negative appeal, I check with the board to make sure that you want to hear it. So a negative appeal, first of all, for those who might not know what that is, it's an appeal against the issuance of a permit. Usually the appeals that we're hearing have to do with the denial of a permit. But in this case, a permit has been issued and a community member is appealing the issuance of that permit because they think that the zoning administrator has made a mistake. So they're a little bit different than the cases that we normally hear. It's a community member, not the property owner, who's appealing. And in this case, as opposed to the one that we heard, I guess it was 2 weeks ago, this appeal was filed timely. So it was filed within 10 working days of the issuance of the permit. So yeah, I just was following the procedure, wanted you to know that that had happened and that it was filed in a timely way, and that because we don't need to wait the normal 21-day posting period, we can put it sooner on the next docket. So that will be on August 30th unless anybody has a problem with that. Okay, I don't see a problem, so I'm going to move on. The last thing on our general meeting docket is the approval of a resolution. This one is 1503 East 28th Street. This was a reconsideration that we heard, let's see, I guess it was on July 26th, does that sound right? The board decided to clarify its June 7th resolution. And so this is one of the ones that have been coming up more and more. This was a multifamily dwelling that became vacant at a certain point, and they wanted to continue now to use the property for the same number of dwelling units that it was used for back in 2010. So this resolution comes to the same conclusion, that the appellant is approved to use the property as a multifamily dwelling with 2 dwelling units, but it goes into a lot more detail about why. It goes into kind of the new code versus there was a provision in the old code that said if a property was vacant, that it had to be considered to be a single-family dwelling, and that is no longer the case. That provision of the code doesn't exist anymore, and so it's kind of our best faith or good faith effort to interpret the prior code and the current code and apply it to these kinds of situations. We actually have a couple of them on the docket today that are similar. So I would love to have a vote to, if anyone has any anything they would like to add or change about the resolution, please let me know. But if not, I'd love to have a vote to approve the resolution.
I'd like to approve.
So do I.
I do as well.
Oh, you weren't present. Okay, great. So that sounds like a 4-0 with 1 abstaining. Thanks for remembering that. Okay. All right, so I think that's everything that needed to be, well, I guess we can go over the docket then. Thank you. All right. Okay. All right, so just going down the docket in order. 2022-223 is on consent. 2022-253 is on consent. 2022-256 is on the regular docket. 2022-258 is on consent. 2022-259 has been postponed. 2022-260 is on consent. 2022-263 is on consent. 2022-226 has been postponed.
You mean 266?
Yeah, what did I say?
226.
Yeah, I meant 266. 2022-267 is on consent. 2022-268 is on consent. 2022-269 is on consent. 2022-271 is on the regular docket. 2022-274 is on consent. And 2022-278 is on the regular docket.
The cases on the regular docket one more time.
Yes, so right now we have 3 cases on the regular docket. They are 2022-256, 2525 Insulator Drive. The second one is 2022-271, 2412 Lakeview Avenue. And the third one is 2022-278, 2212 Essex Street. Want me to carry right along? Okay, so good afternoon, everyone. Welcome to the August 16th, 2022, 1 p.m. docket for the Board of Municipal and Zoning Appeals. My name is Becky Witt, and I'm the Assistant Counsel to the BMZA, as well as currently the Acting Executive Director. And to my right are the board members who will be deciding your cases today. We have from left to right, Otis Freeman, Leland Shelton, James Fields, who's the chair, Bill Cunningham, and Sabrina Johnson-Turner. If you haven't already, please silence your cell phones. If you need to have a conversation with someone, please do so out in the lobby. When it's your turn to speak, please identify yourself and spell your name for the court reporter who's over here across from me, and be sworn in to testify. If you haven't already signed in, but you would like to speak today on any issue, please sign in at the sign-in sheet here at this table. So the board will vote today, and their vote doesn't make the decision final, so we have to issue a resolution. And those can take up to, or sometimes more than 30 days to be issued. So we try to get them out within 30 days, but if you haven't heard back from us after 30 days, please feel free to check in. If you're unhappy with the outcome of your case, you can request reconsideration within 10 days, or you have the right to appeal the board's decision to the circuit court within 30 days of the issuance of the resolution. And I think that's it.
Okay. Welcome, everyone, for this session of the BMZA. As Ms. Witt indicated, we will endeavor to deliberate on your matter to the extent it's not on the consent docket, if it's a regular docket matter. And you may feel free to stay and listen in on that deliberation. However, you cannot participate in that. We do ask that once we do render a decision, that you not take any action in furtherance of your project until you have received your decision. And certainly don't take any action in furtherance of your project without pulling the proper permits in Baltimore City. Our docket is broken into 2 parts. One is the consent docket, which you've heard about, and the regular docket. On the consent docket, those are matters for which the board believes it has sufficient information to approve the appeal. And so the process for those matters are I will call the case numbers, and all the applicants will line up behind the podium, and we will call your case, we will hear reports from staff and from the planning department, and then we will resolve your matter. For all intents and purposes, that is an approval of that matter. With regard to the regular docket, we will call those cases. We will hear from the applicant first, then we will hear from any opposition, and the applicant will have the final word. On those matters, again, we will endeavor to deliberate immediately after your case. We don't anticipate a tremendously long docket today, but we'll try to keep it moving. With that said, we will, again, just want to note the matters that are postponed today. Case number 2022-259, 2127 East Pratt Street. The appellant is Lou Catelli. That matter has been postponed. Not exactly sure when that'll be reset, but 2127 East Pratt Street, if you're here for that matter, it will not be heard today. The second postponed matter is 2022-266, 4200 Liberty Heights Avenue. Len Faust is the appellant. Again, 4200 Liberty Heights Avenue, that matter is postponed today and will not be heard. Now I'll commence to call the consent cases, and again, line up in the order in which the cases are called, and we will take up your matters. First case on the consent docket, 2022-223, 613 Parkworth Avenue. Juan Carlos Romero Alonso is the appellant. Again, come up to the podium, and the remaining cases will line up behind you in the order in which they're called. Next case on the consent docket, 2022-253, 1500 Bolton Street, AB Associates is the appellant. And then we have 2022-258, 1920 East Landfill Street, Sherrard, Houston, the appellant. Case number 2022-260, 2118 Drew Hill Avenue, William Brodus. Case number 2022-263, 1300 West Lafayette Avenue, Ethel's Investment Group is the appellant. Case number 2022-267, 3708 Windsor Mill Road, Roy Mack is the appellant. Case number 2022-268, 800 North Broadway, Sean Dowdy is the appellant. And case number 2022-269, 403 South Wolf Street, Juan Carlos Lazarte, the appellant. And finally, case number 2022-274, 728 Deep Dean Road, Adam Corballo is the appellant. If I could have all these parties sworn.
Hello, I'd like you all to please raise your right arm for me, please. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth? Okay.
Okay, let's get it started. Case number 2022-223, 613 Parkworth Avenue, Juan Carlos Romero Alonso. Good to see you folks, welcome back. And the purpose of this appeal was to install a roll-up metal gate 12 feet wide and 9 feet tall on the right side of the house. And this matters, you've been before us before, and we had requested some additional information. I believe it was some photographs of the fence that was at issue. Have you all provided that information? Okay. Well, let's hear from staff and planning, and then we'll hear from the applicant.
So the variance being requested is a minimum interior side yard setback, 10 feet being required, 0 proposed, so it's a 10-foot variance. Like the chair said, this is the second time the case has been heard. We asked for more information about the fence, and we received the copy of the permit for the fence that is attached to the proposed gate. And I'll let planning speak for themselves. There was some concern from planning that the backyard would be used as a contractor storage yard, which is not permitted in this zoning district. And just a suggestion to the board that they could approve, if they want to approve this gate, it could be with the condition that the owner cannot use his property for a contractor storage yard. And the definition of that is included for you in your notes. There's also 4 letters of support from community members in the file, or from not just community members, but people who live nearby on the block, basically.
Thank you. Martin French for the Baltimore City Planning Department. Planning Department, as your staff has noted, was concerned about the possibility that the combination of the gate and the high fence could allow enclosure of a contractor storage yard, and this is an R5 zoning district where that type of use is prohibited. That was the department's primary concern, and if the additional information provided allows the board to approve the application, the department has no further comment. Thank you.
Thank you, Mr. French. Okay, so you provided the additional information with regard to the fence. Do you intend to use this property as a contractor storage yard?
No.
Okay. Any questions from the board?
No.
Is there anything you'd like to add to your application at this time?
No.
All right. Will the board, having heard your appeal, we believe we have sufficient information to approve your appeal on the condition that the gate and the property is not used as a contractor storage yard, as we've heard before in testimony, okay?
Yeah.
All right, very well. Thank you for your time.
Thank you.
Thank you so much.
All righty. Case number 2022-253, 1500 Bolton Street. AB Associates is the appellant. Good afternoon, Mr. Berry.
Good afternoon.
This is a request to use the first floor of the premises as an office and accessory retail in basement and garage. Is that correct?
That's correct.
All right. We'll hear from staff and planning.
Sure. So this is a request under neighborhood commercial establishment section of the code for office and retail sales. Those are both allowable under that section. The land use cards show a history of commercial use of the property, including as an antique store and then a custom frame shop and an art gallery. The only question I think that I had is whether existing parking spaces are being removed or are they remaining on site?
Thank you. Planning Department reviewed the application, noted that this property is in the Bolton Hill Historic District, and therefore is recommending that approval of the application be subject to the condition that all exterior changes, including additions, demolitions, alterations, and signage, are completed or installed in accordance with an authorization to proceed issued by the Commission for Historical and Architectural Preservation. Thank you.
Thank you, sir. Okay, Mr. Berry. Anything you'd like to add to your application today?
Not too further to add, I think we submitted a large number of community support letters. They should be in the file, and thank you.
All right.
Thank you for-
And, I presume you have no issue with complying with CHAP conditions?
No, we're in the process and have been for many, many months.
All right, very well.
And have received their approval to
Gotcha.
proceed.
All right. Well, the board, having heard your appeal, we believe you have sufficient information to approve your appeal. Thanks so
Thank
much.
you very much.
Case number 2022-258, 1920 East Landfill Street, Sherrard, Houston.
Yes.
Good afternoon, ma'am. This is a request to increase the capacity on the existing home daycare from 8 children to a large family daycare consisting of 12 children. Is that correct?
Yes.
All right. I'll hear from staff and planning.
So, again, this is a change in the existing conditional use. So they want to increase the number of children from 8 to 12. And I did have an email interaction with this applicant who provided some more information about the number of staff and pickup and drop off and parking and lighting. They're going to have 2 staff. Pickup and drop off is via a side door. There's no off-street parking there, and there's exterior lighting near the front and side doors.
Thank you.
Planning Department has no comment on this application, but is supportive of additional child care resources in Baltimore City. Thank you.
Thank you so much, Mr. French. Ms. Houston, is there anything you'd like to add to your application at this time?
No.
All right. Any additional questions from the board?
No.
All right. Well, the board, having heard your appeal, we believe we have sufficient information to approve your appeal. Thank you.
Okay. Thank you.
Case number 2022-260, 2118 Drew Hill Avenue. Mr. Broadus?
Yes, how you doing?
Good afternoon, sir. This is a request to use the premises as 2 dwelling units, correct?
Yes, continue to use.
Continue, all right. Ms. Witt, from staff and then from planning.
Sure. So the city's files show the current use of this property is as a multifamily dwelling with 2 dwelling units. The BMCA approved this use in 2008, and then the property became vacant at some point. But the most recent use that we have, which has been consistent over time, is as 2 dwelling units. And multifamily is a permitted use in the R8 zoning district.
Thank you.
Thank you. Planning Department has no objection to approval of the application and recommends that the board condition the approval on the applicant operating the property in compliance with the terms and conditions of the Baltimore City Code Article 23, which is the sanitation code. Thank you.
Mr. Bronis, do you have any, do you agree to operate in compliance with that condition, sanitation code?
Yes, sir.
All right. Is there anything you'd like to add to your application at this time?
No, sir.
All right. The board, having heard your appeal, we believe you have sufficient information to approve your appeal. Thank you.
Thank you.
Case number 2022-263, 1300 West Lafayette Avenue. The appellant is Ethel's Investment Group. And your name, sir?
My name is Morris Henry.
Morris Henry. Mr. Henry, thank you. Welcome. This is a request to use the first floor as a clothing store and to use the second floor as a barber/beauty shop. Is that correct?
Yes, sir.
All right. I hear from staff and planning.
So this is, like you said, to use the second floor as a personal services establishment and the ground floor for retail sales. Those are both neighborhood commercial establishment uses, and there's been a long commercial history at this establishment according to the zoning cards.
Thank you. Planning Department has reviewed this application, notes the property is qualified for the use, and recommends approval. Thank you.
Thank you, Mr. French. Mr. Henry, is there anything you'd like to add to your application today, sir?
No, sir, I don't.
All right. The board, having heard your appeal, we believe we have sufficient information to approve your appeal.
Thank you. Have a good day.
Thank you. Good luck to you. Case number 2022-267, 3708 Windsor Mill Road. Roy Mack is the appellant.
Good afternoon.
Good afternoon, sir. Are you Mr. Mack?
Yes, sir.
Good afternoon, sir. And this is a request to use the premises as office space. Is that correct?
Yes, sir.
All right. Let me hear from staff and planning.
All right, so this is another neighborhood commercial establishment use for offices. There's a significant history of commercial uses at this property as well, including a tailor shop, retail goods, beauty shop, laundromat, et cetera, over the years. There is one question. Mr. French and I were having a discussion about this, about all the cases earlier, to ask about the office use. I think there's some community concern about a possible healthcare clinic at this established or at this property, and so we wanted to hear more to make sure that it was actually going to be used for an office and not for a healthcare clinic. So if you can just give a quick discussion of that.
Yes, Restoring Hope for Minds, we do community mental health, meaning services are provided inside of homes in the community, not inside of our office space. So we currently are in a few schools as well as community centers. So that's where we provide our services as well as in home.
And the offices will be primarily administrative use?
Yes.
Okay. All right, great. Mr. French?
Planning Department, having heard that explanation, has no further comment. Thank you.
Thank you, sir. Mr. Mack, is there anything else you'd like to add to your application at this time, sir?
No, sir.
All right. Well, the board, having heard your appeal, we believe we have sufficient information to approve your appeal. Thank you so much.
Thank you so very much.
Thank you.
All
Have
right.
a great day.
Good luck to you. Likewise. Case number 2022-268, 800 North Broadway, Sean Dowdy. Good afternoon. You Mr. Dowdy?
No, I'm actually David Swank. It's a multi-member LLC, and I think they just put Sean's name on the
Okay.
top.
I'm sorry, could you say your last name one more time?
Swank, S-W-A-N-K-E.
Great, thank you. This is a request to use the premises as a multifamily dwelling that will consist of 5 dwelling units.
Yes, it's zoned as a 4-unit, and it's been used as a 5-unit for a long time. It was a pre-existing 5th unit that we didn't know about upon purchase, and we wanted to use it as live-work for somebody living on the premise who's going to take care of the apartment complex. It's a side building with its own entrance, cut off from the rest, and we were surprised upon closing and inspection of the property to find the 5th unit. But it had been utilized and rented out to a student before we purchased the property, so it existed already. It's an existing 5th unit structure.
Okay, thank you. Let's hear from staff and planning, and then we'll come back to you, Mr. Dowdy. I'm
Sure,
sorry,
so
Mr. Swank.
the application is to use the property as a multifamily dwelling consisting of 5 units. There's a long history of multifamily dwelling use, all the way back to 1931 when it was used for a 4-dwelling multifamily unit. I think consistently through our records, it's been listed as a 4-dwelling, multifamily dwelling. So the variances that are being requested here are minimum lot area, 1,775 square feet is required, 1,575 square feet is proposed or exists, so it's a 200, I believe, square foot variance requested, and then a 1 off-street parking space to add an additional unit. And from the application that we had, it said that the proposed additional unit would be located where there had been a commercial space in the building.
Okay. Planning Department reviewed the application, noted that this property is in the Gay Street 1 urban renewal area. That urban renewal plan does not prohibit the proposed use. No further comment from the department. Thank you.
Thank you, Mr. French. Mr. Swank, is there anything else you'd like to add to your application at this time, sir?
So I didn't exactly hear what the planning department said, but it was a pre-existing fifth unit. It was always rented out as a fifth unit before purchase, and we own a parking lot in our company that's about 3 blocks away that has 15 additional spaces. I think I submitted a picture of my application, so all tenants and the person who's going to live in the live-work unit would use the parking lot, so there would be less congestion.
Okay, very well. Mr. French, you want to just confirm your commentary?
I would just comment that in that situation, it sounds like the board would need to grant a variance of the distance requirement between the parking available and the structure in question. There is, I believe, a 600-foot maximum allowed by right. So if it's more than 600 feet distant, then that would be an additional variance included with the approval.
No problem. All right. Is there anything else you'd like to add to your application at this time?
No, but we're very happy to rent out an additional parking space from a garage or somewhere and provide it to the person who's going to be in the live-work unit, whatever needs to be done.
Okay. Any questions from the board? All right. The board, having heard your appeal, sir, we believe we have sufficient information to approve your appeal. Thank you so much. Approve that as a variance. Case number 2022-269, 403 South Wolf Street. Juan Carlos Lazarte?
Yes.
Wonderful. Welcome, sir. This matter addresses variance to bulk regulations related to the construction of a 3-story rear addition. All right. I'll hear from staff and planning.
So there are 2 variances being requested. One is for the minimum rear yard setback, 20 feet is required, 10 feet is proposed, so it's a 10-foot variance. And for maximum lot coverage, 80% is allowed, so it's 92% is being proposed, so it's a 12% variance being requested. And I believe we got some late letter of support in this case from the community association.
Planning Department has no comment on this application. Thank you.
Thank you, sir. Ms. Lazarte, is there anything you'd like to add to your application at this time, sir?
Well, actually, we did 2 applications. And one was the one that described, and the other one was something reduced with only 1 floor, one master bedroom on the top.
Okay, so we're here.
We are not going out of the perimeter.
Okay, just to be clear, we're here at 403 South Wolf Street, and what we've been asked to address is related to the construction of the 3-story rear addition. Is there some other construction that you're seeking approval for?
No, we are in the process to get.
Okay.
I think what he was saying was that there was a second set of plans that was a smaller addition than your original set of plans.
Yes.
Okay.
So what we're approving was the original application. I don't think we have a second set of plans in our file. Which I'm not sure how to deal with, because if he was asking for more, then certainly we would require him to come back.
Correct.
But since he's
for less.
asking for less, I think we can still approve this. And maybe we'll follow up with you afterwards to make sure that we have the right set of plans. But I think what we should do is just approve what we have and then see if that works for the second set of plans going forward. I can do that in a conversation with
We
you.
presented the second set of plans.
Okay, I don't have them, but we can talk about it later.
We did like 3 weeks ago or 4 weeks ago.
Okay.
It's sort of like a lesser included offense. The plans for which you're seeking approval are included in the broader ones that are listed here. So with that understanding, the board, having heard your appeal, we believe we have sufficient information to approve your appeal, pending confirmation of those plans within that approval by Ms. Witt. All right? Thank you, sir.
Sure, thank you.
Case number 2022-274, 728 Deep Dean Road. Mr. Caballo, welcome. This matter addresses a variance to bulk regulations to construct and open the porch in the front and a pergola on the side. Is that correct?
That is correct.
All right. We'll hear from staff and planning.
Okay, there's two variances being requested. The minimum front yard setback, 25 feet required, 17 feet proposed, so it's an 8-foot variance. And a minimum interior side yard for the pergola, 10 feet is required, 0 is proposed, so it's a 10-foot variance requested.
Planning Department has no comment on this application. Thank you.
Mr. Caballo, is there anything you'd like to add to this application, sir?
No, sir.
All right. The board having heard your appeal, we believe we have sufficient information to approve your appeal. Thank you.
Thank you.
Okay, and that concludes our consent docket, so we'll turn our attention to the regular docket. Okay, calling case number 2022-256, 2525 Insulator Drive. Caroline Hecker, is the appellant, represented by Justin Williams. Welcome, sir.
Good afternoon.
And this is a request to subdivide the property and construct single and multifamily row house dwellings, including front-loaded attached garages that occupy more than 50% of the width of the front facades of the dwellings. Is that correct?
Yes, and I wanted to add one more variance that kind
Okay,
of
thank you.
wasn't called out specifically. It's the same section, 15-211B. So the one you read was the 50% facade, and the other one is that the front facade and garage will be 0 feet in lieu of the required 5 feet back.
Okay.
Were you short? They'll go.
I think we're good. All right. I'll hear from staff and planning.
All right, I don't have a lot to add here, other than the variances, which have already been stated. Front-loaded attached garage requirement, 50% of the front facade is allowed, and then based on Mr. Williams just now, these are unusual variances, so it feels awkward to read this out loud. To permit a front-loaded attached garage to be located 0 feet behind the main front facade of the proposed buildings in lieu of the required 5 feet on certain lots within this development.
Okay.
Planning Department has been working with the applicant on this subdivision for a while and wishes to note that the property is partly in the Chesapeake Bay critical area and in the regulated floodplain. The proposed uses have been cleared or approved as far as those particular requirements are concerned. The subdivision and development plan require approval by the Planning Commission. This particular subdivision plan was reviewed by the Site Plan Review Committee on May 4th and approved with comments. And the final determination, of course, of the final form of the development plan is resting in part upon the decision of the board today. Beyond that, the department has no comments at this time.
Thank you, Mr. Clark. Okay, Mr. Will?
Thank you.
Williams, floor is yours.
Good afternoon, Mr. Chair, members of the board. So I guess the big picture request is to walk you through it in case you weren't familiar with the terminology. So what's proposed here is a large subdivision in Port Covington, the Lock and Slater site, which I'll walk you through. But the specific request before you today is for 42 24-foot wide row homes. There's a illustrative elevation in your packet. The final design is being reviewed and will eventually be approved by the Planning Commission or the planning staff and UDAP. But this is for your reference. And so what's proposed here is 2-car garages along the front part of the row home. And basically any 2-car garage would be more than 50% of the facade. I think the intent is to maybe reduce the garage door impact on the sight line, but I'll walk through why it's required here and necessary here. And similarly, because this is a row home, the garage will be flush with the front facade and not set 5 feet back. So those are the requests, and I'll give you some background about the site and walk you through it. I haven't seen it all in person, so we killed a lot of trees like usual with exhibits for you to see. This is the Lock Insulator site in Port Covington. You see it in the neighborhood context exhibit marked in red. It's showing the site. It has long-term history of industrial use since the 20s, when Lock Insulator came from New York and was drawn to the Port Covington area for the railroad and the port access. It closed in 2017. There's an article in a couple articles in the exhibits for you to review on that. And since 2017, it's been vacant. The applicant here, Mark Saperstein of 20 Walker Development, has acquired the rights to the site and has sought approval to redevelop it residentially. There's a broader plan. It's shown generally to do multifamily housing development, row home development, and a bunch of amenity space in there. As part of this preliminary work with the site, the applicant met with Councilman Costello, who agreed to rezone the site from the former I-2 zoning district to its current Port Covington 3, like PC3 zone, which is pretty generous. It allows a lot of different development types, uses, but right now in the field, it's basically a vacant industrial site, so it'll be torn down and raised and redeveloped as a brownfield redevelopment site. I forgot to mention, Mr. Saperstein has a successful history of developing brownfield sites in the past, including the former Chesapeake paperboard site for McHenry Row, and over in Canton, the former Exxon Standard Oil site in the Canton Crossing. And so hopefully he'll bring that success, or he intends to bring that success here to today with the board's approval. So I'll give you the specific site plan. It's 11 by 17. Piece of paper in here showing the site. Connecting down. The large white square is the current, where the proposed multifamily housing is going to go, but that's not part of this application before you today. To the south of that is where Nick's Fish House is, to orient you. The broader plan too, there's an exhibit that shows how it connects to the Port Covington, while they're now a MAG development site. As part of the UDAP process, the planning staff has worked to make sure it's compatible with the surrounding area, and that'll not only go into the street grid, but also kind of tie into the proposed trail and bike trail that'll go around the rest of Port Covington into Ferry Bar Park. And so that's basically what's driving this specific design choice today. So another exhibit here. The waterfront improvement zone, this is one I'll draw your attention to. So behind the rears of the townhomes facing the water is proposed a 10-foot wide walking bike trail and then a larger landscaped area. That's all part of the Chesapeake Bay critical area that Mr. French mentioned to promote, I guess, better development in the close proximity of the waterfront. And so to provide for that, as opposed to providing roads in the background or alleys or streets, the garages that would normally be in the rear of a row home, for these homes, are going to be in the front of the row home. So I guess to specifically draw your attention to the request again. There's going to be a total of 42 front-loaded row homes that are 20 feet wide along the site. Sorry. I used the paper anymore. It's along the front, along these darker gray homes along the edge of the site. Another thing we're doing on this site is narrower streets, so there will not be on-street parking here. So another reason that drives the need for two-car garages is that to have a narrower street grid, less pavement close to the water, a more walkable area. We're narrowing the streets, but we need people need place to have park their vehicles. So we need two-car garages. Each of the row homes, like I said, will be 24 feet wide. With the average, we don't have the final design approved yet, but if a garage is, say, 20 feet wide, that would be 84% of the facade, which is more than the permitted 50%. And then the same thing as a row home, the garage would be flush with the front facade as opposed to 5 feet setback. To walk you through the actual standards that you have to consider for practical difficulty, the site is unique because it's next to the waterfront. It's one of the only proposed waterfront row home developments in the city that doesn't require a promenade because it was formerly industrial, but the developer on his own accord has agreed to connect to that. And so he would normally have the ability to do an alley and a rear access to the site. But because he's agreed to do the promenade and walkability and public-facing features, there's a need to have the front-loaded garages. I can walk through the rest of the standards, but they're in the outline in front of you. I don't want to take up your time. I guess have you done the remediation plans? Remediation plans was the question.
Or the remediation plan?
Yeah.
Yes.
Good
Hi,
afternoon,
I
Mr.
am the developer, Mark Saperstein.
Yeah. Yes, please.
Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes,
All right.
so I am the developer, Mark Saperstein, and you had asked about remediation plans as far as like cleaning the site up? Yeah. Yes, so I've already taken it through the process with the Department of the Environment, MDE, and we have an approved EMP, which is the Earth Management Plan, to bring in clean fill, remove what is not so clean, and then that's all part of our plan. So we're going to start demolition the third week of September and deliver, because you know how I work, right? So we're going to deliver the first homes to be built by April 1st of next year. And then it's about a 3-year process to build that many units.
Very ambitious. Great, thank you.
Sure.
Any more questions? All right. Obviously, there is no opposition to this project, is that correct? All right. I think we're good, Mr. Williams. Thank you. Thank you, Mr. Saperstein. Appreciate it. And Ms. Hutchins. Thank you.
Thank you.
You on that, please? Okay.
Okay, because of the particular surroundings and the shape of this plot of land, given its proximity to the water and previous use as an industrial building, the plan is to make the streets narrower so that it's more walkable, so that there's less, contamination is not the right word, so that we leave the water alone as much as possible. And it would be unnecessarily hard to do that for people to live there with cars if you didn't give them a space for 2 cars in a house that's big enough for like 7 people. So the conditions are unique to the property and are not generally applicable to the rest of the property in the same zoning district. And the hardship is caused by the code and is not created by any intentional action or inaction of any person who has an interest in the property. So for those reasons, I believe that the variance should be approved.
I agree, and I would also note the submission by the applicant, which lays out the legal standard, in addition to what you said, Sabrina. And frankly, I would adopt as findings, what's presented in that submission. And for those reasons, I believe it's appropriate to approve this application.
I agree.
I agree with what we just stated.
I agree, and I have to thank Sabrina for her breakdown, as well as for the applicant who did a wonderful job of breaking down the standards as well.
Yep. Okay. I think that's a unanimous one. Good. Okay, thank you, folks. Case number. Wait a minute. Yes. 2022-271, 2412 Lakeview Avenue. Jennifer Wicks is the appellant. Good afternoon, ma'am. This is a request to use the premises 3 dwelling units?
Yes.
Okay. I'll hear from staff and planning.
Sure, so this is This is a request to use the premises as a multifamily dwelling with 3 dwelling units. This property, according to city records, has an existing 3 dwelling unit use. There's certainly been a period of vacancy here that seems pretty significant. Multifamily is a permitted use by right in the R7 zoning district. And the city's files shows the current use as a multifamily dwelling with 3 dwelling units from the 1950s through the 1970s. We do have a letter of opposition, which I believe should be in your packet, but if not, I believe there are people here to testify on this issue. I think kind of the main issues brought up by the letter are that the neighborhood already has sufficient rental units, that there's parking issues, and that the density would be too high to allow this property to continue as a multifamily dwelling.
Thank you. Planning Department has reviewed this application and has no comment, but if the board approves of this application, the department requests that it would be conditioned upon operation of the property in compliance with the terms and conditions of the Baltimore City Code, Article 23, which is the sanitation code. Thank you.
Okay, first, is there anyone else here for this project? You need to come up so we can have you all sworn.
How y'all doing? Just need you to raise your right arm for me, please. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
I do. Okay,
You have 2 also.
You as well.
okay. Do you, hold on, let me get my tongue together. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
Okay.
Ms. Wicks, to the extent that the board would be predisposed to approve your application, would you agree to comply with the Article 23 sanitation code as described by Mr. French?
Could you brief me on what that sanitation code is?
Sure.
Okay. Baltimore City Code, Article 23, Sanitation, 2021 edition, establishes a limit of 96 gallons volume of garbage and trash from multifamily residential property weekly. It will be important for the owner to comply with the sanitation code by providing at all times each future dwelling unit's resident with a designated container and to construct and maintain a place near the rear alley for storage of such containers. This would help to reduce the potential negative impacts of having multifamily dwelling use of this property. Should the residents generate more garbage and trash than the amount that the Department of Planning Works ordinarily removes, Department of Public Works, ordinarily removes on a weekly basis, the owner should be prepared to contract with a private waste hauler to service this multifamily use.
Yes, I agree to that.
Okay, thank you. And we'll hear from you, Ms. Wicks.
Okay. So I just acquired this property on July the 6th. As stated previously, this dwelling has been vacant for over 20 years. I stepped in to take over the project. We will be redeveloping this as a 3-unit building. I am working with a really reputable construction team, and we're hoping to get started this month. We plan to finish around like the end of March, the beginning of April. We have received approval from Baltimore City to move forward with the project since it's been vacant for so long. We also received CHAP approval, so this will be a CHAP building. We will try to preserve as much as many historic features as we can on the building. Unfortunately, the inside has to be completely demoed, but we'll be keeping like the vestibule, the transom window, and we'll be redoing the cornice at the top as well as like wood floors. It's going to be a pretty good, a pretty nice building. Our target market for this would be working professionals. We have not decided on a rental price yet, but it'll be anywhere between $1,500 and $2,000 per month. And it will be set up roommate style. We have also addressed the parking issues in the site plan that I believe that you have. If you don't, I have copies. the site plan allows for 3 vehicles. Baltimore City has already approved this to be a duplex, so that, addresses 2 parking spaces that would be able to technically be on the street. So all we really needed was a parking pad in the rear that could accommodate 1 car, but we are accommodating 3 cars in the parking pad on the rear.
You said 3 cars in the parking pad in the back?
Yes.
Okay. And do you know what size each of your apartments is gonna be? 1 bedroom, 2 bedroom?
Sure, they're 2 bedroom, 2 bathrooms on each floor.
Okay,
Roommate style, so
gotcha.
each person will have their own space, and that'll help, again, with the rent and the demographic that we're going after, because technically it'll be, 2 different household incomes coming together to pay. I will be on site, for the community members came out in opposition, I will be on site probably about 5 days a week overseeing the project. Again, I want to make sure that this project and the property maintains the integrity of the neighborhood, but it has been vacant for some time, and we all know vacant properties can present a hazard. There was a fire maybe about 20-something years ago, so we're really looking forward to putting everything back together, and I'm happy to answer any questions. I have attended a few community meetings, so if you'd like to have me present and tell the community a little bit more about the project, I'm happy to do that as well.
All right, thank you. Any additional questions for Ms. Wicks at this time from the board?
Yes, sir.
All right. Thank you, Ms. Wicks. We'll hear from you at the end, and we'll hear from the opposition. Just come up and state your name.
Well, my opposition to the properties is...
Sir, your name?
My name is Larry Lee.
Lee, L-E-E?
Yes, L-E-E. I own the
Okay.
property at 2411 Lakeview Avenue, right across the street.
Okay.
My opposition to the property going 3 apartments, I approved of 2 because of parking. That's the main opposition. And the value of my home, I believe, will be impacted if she put a 3-story apartment building in there. Because of the size of the house, I believe that the units would be probably around 1,000 square feet with 2 individuals, as she said. So I'm thinking that could potentially bring 6 automobiles and cars and things like that just for that one property. We have alternate street parking in that area. So once that alternate street parking resumes, parking is going to be a real bad issue for those 2 days a week in that area. So those are my oppositions.
Okay, thank you, sir.
Thank you.
Hi, my name is Amelia Cox, A-M-E-L-I-A, last name C-O-X, and I also live right across the way at 2407 Lakeview Ave. I am responsible for submitting along with my neighbors, the letter of opposition that I believe you have in your packets. I don't know what protocol is. I don't necessarily assume I'm to read the letter. I guess I would characterize overall our opposition as this does not, 3 apartments would not meet current city code. 3 parking spaces would not meet current city code. So my understanding is that this is all coming in because of historic use. And as a member of the community, I'm baffled that the board finds it harmonious with the current code that Baltimore's vacant homes could all be rehabilitated to the uses that they were seeing in the 1950s through 1970s on the zoning summary cards when our population was double what it is now. So I believe this is not a harmonious use with the current city code. And I don't know how we overcome that history when it seems that the zoning summary cards trump everything. I've also tried to access those and have not been successful, but I will keep trying. So additionally, on the assumption that this is going to be approved because of the zoning summary cards that I can't access. Neighbors are speaking forcefully about the parking issue, alternate side street cleaning. Additionally, we have large untended sanitation issues on Lakeview Avenue already. We work on a weekly basis, if not more, contacting the city, asking for help, and it is not tended to. So the intentions of any individual developer are not particularly persuasive to me. Everybody comes in saying they're going to do what they're asked to do, but the accountability seems to be almost nil. And that is troublesome, and we're the ones who bear the burdens of that, picking up trash and dealing with rats and watching what's happening to our neighborhood. So I guess I would also like to note for the record, yes, there was a structure fire in 1999, so I hope that inspection is thorough because I'm concerned about the structure.
So what do you believe would be harmonious with the community in terms of the development of that site?
Thank you. I think the current code standards speak to it really well, that it could fit two, and then there would be a variant. I believe that it can fit, according to the current code, the lot could fit one parking spot, so it would need a variance for the other, I think. We have no objection to that. Having 2 units in that building seems a more reasonable with what the neighborhood is, and would match what the current code is, which, as I understand, was revised so that it wouldn't replicate what had been going on before.
Okay. Any other questions?
I have a quick question. Would you be willing to work with the developer or renege your opposition if she were to agree to any conditions we put on the property, such as she comply with this sanitation code?
I think conditional approval, the neighbors would certainly desire conditional approval so that there was more accountability for parking and sanitation. Understand I'm the only person in this situation not making money on it. So developers are making money, people are here on salary, and we're trying to take care of our families. So I'm not entirely sure what work with the developer means. Maybe you could be more specific. I'm dealing with landlords on a regular basis, and they're telling me that it's the tenants' problems, that the trash is a mess, that they can't help the quality of who they've got in there as long, everybody's.
Well, we've heard from Mr. French as to what the Article 23 of the Sanitation Code requires, and those seem to be fairly specific requirements. We do have on record the developer agreeing to comply with those conditions.
Yes.
As a
yes,
start.
So I guess our concern comes from lack of accountability. So 2402 Lakeview Avenue, which was approved by the board in October 2018, also long vacant, and for 3 units has been since the point that it became occupied a continuous ongoing source of sanitation issues, which the owner does not address, and the tenants are unable to address, and the city seems unwilling to deal with. So yes, the law is the law, and accountability to that law from our perspective in the neighborhood is not consistent. So it's worrying. I don't know what work on it means because we're already working on it, I guess.
Okay. And we also have at least a recognition of parking issues and an agreement to provide parking space for at least 3 vehicles.
Mm-hmm.
But I take it that does not.
I guess I'm hearing that there are going to be 6 working professionals, or that the hope is that there are 6 working professionals. So that's 3 people
perhaps,
using.
but we don't know if there'll be 6 vehicles associated with that. So.
No, we don't. It's not unreasonable. It is not outside the realm of reasonability to think that there could be.
Sure.
And for what it's worth, the alleys are often impassable due to trash. So then you might be looking for on-street parking. So it's a hot little mess of compounding issues. I'm not saying any one person has the solution. I don't think they do.
Good. All right. Anything else from the board?
No, I'm good.
All right. Thank you, ma'am.
Thank you.
Ms. Wicks, you have the final word.
Sure, just wanted to point out two things. Without the 3 units, the project would not be financially viable. That's one thing. The other thing, as far as property values, the property has appraised. We ran a test. It's hard to know before it's actually done, but it would appraise for about $475,000. So we're certainly not looking to lower property values. And again, we have addressed parking with the rear parking pad. I will be on site, like I said, to work with community members to make sure that everything remains in compliance. I'll be completely transparent about the process. And not only am I the developer, I intend to hold on to the property for at least the next 10 years. So I will be personally responsible for any like excess trash or any parking issues that come from the tenants who are in there. So I will definitely make sure that everything is up to code and being followed, because I don't want to be fined. So that's all I have to say. Thank you.
Okay. Anything else from Ms. Wicks before she goes? All right. Ma'am, thank you for your presentation. Mr. French.
For the benefit of all concerned, the reference to 2402, which we just heard, that was approved in 2018 by the board. I believe at that time, the planning department was not requesting and the board was not making a condition of approval compliance with the sanitation code. The planning department has learned from experience, as you've heard, that sometimes it's important to do that. The significance of making a conditional approval in this situation would be that the previously approved property at 2402, when there is a sanitation violation, is handled through the sanitation code enforcement process only. When the board makes a condition of approval, that then becomes a condition for retaining the use permit for the property, which puts much more onus on the property owner to comply with the requirements of whatever that condition may be. And in this case, it's the sanitation condition. That's all. Thank you.
Thank you for that additional information, Mr. French.
Mr. French, would that be as we move forward, would that be a request that you guys make?
We are trying to make it on a regular basis for multifamily dwellings throughout the city. Yes,
Oh, that's
again,
good to hear.
we have learned from experience.
Great. Thank you so much. Okay.
That was one question. So the variance is just for the square footage, correct?
So here's the way that I kind of look at it. The request is for a multifamily dwelling with 3 dwelling units. So multifamily, like I said, is a permitted use by right in this zoning district. The last legal use of this property is as a multifamily dwelling with 3 dwelling units. So basically, this makes it a permitted use. However, the structure as it currently exists is non-conforming. So because the density is higher than what would be permitted by right? So the community members were talking about how this property would allow 2 dwelling units by right, meaning they wouldn't have to come to us. But there historically have been 3. So for non-conforming structures, those are allowed to continue as is, as opposed to non-conforming uses, which can expire. So basically, this is not really a variance, because a variance involves a change, some kind of change in the property. This property is not being changed. It is continuing in the same use and the same density that it's been for many decades. So from my perspective, I don't think a variance is necessary here. And also because this is the last legal use of the property, Katie and I have had a lot of discussions about this. It would seem that we would not really need to approve this, that the zoning administrator could approve this on his own. However, he has been forwarding these kinds of cases up to us for our approval. So we've just been affirming the last legal use of the property because that's what we think that we can do as the board. That's kind of a long and complicated answer to your question. But I don't really think that a variance is necessary here because nothing's changing. It's just a request to keep using the property the way it was last legally used. So it's more of like an affirmation of the existing use, is how we've been thinking of it.
Have we done that? Yeah, when's the last time we did one of those?
Well, we did it for this 28th Street case that we just approved the resolution for. We did it for the Loudon Street case that we did an amended resolution for. We did it earlier today for this is 2022-260, the Druid Hill Avenue case we approved on consent. We do this, I would say, once or twice a month easily.
Okay.
And like I said, I don't think the BMCA is separate from the zoning administrator's office. So we accept whatever appeals are forwarded to us, and we have to consider them and rule on them. I think, as the attorney for you all, I think that the zoning administrator has the power to approve these administratively and not forward them to us, but he has chosen not to do that, and he keeps forwarding them to us, so we have to rule on them. So that's where we are.
Could you repeat that, please?
Yeah, so.
I'm just kidding.
I mean, I can keep repeating it over and over again if you want. It's an interesting situation, and not to get too deep into the weeds, but under the previous code, before 2017, if a property became vacant, not to repeat myself, but if a property became vacant, then the board had to consider it to be a single-family dwelling, even if it had been used for a multifamily dwelling for a long time. That section of the code does not exist anymore. We can't apply it anymore because it disappeared with Transform. So I think that is partially why the zoning administrator is forwarding things to us, is with these lengthy periods of vacancy, is because of that old provision of the old code.
Okay, yeah, I understand. That was my question. I thought I saw this before, and I wasn't sure whether this was the same circumstance or not. Okay.
Yeah.
Okay, time to deliberate. So it doesn't appear that this is a variance, or that a variance standard would apply. We have an affirmation of a pre-existing use, and an affirmation of the use that's consistent with what it had been, both in terms of density and so on. So parking issues existed then, exist now. We do have the appellant offering and agreeing to provide at least space for at least three vehicles. We don't know what the makeup of the tenants would be. It may be that there are only three vehicles that come into the property, but has agreed to the sanitation issues. Mr. French provided some additional information as to why it's a much more draconian agreement to impose a conditional, make it a condition of the appellant's compliance with Article 23, the sanitation code. So there's more teeth to that and more accountability to the owner. Again, without needing to go through the standards for variance, or even frankly applying the Schultz v. Pritt standard, I am in favor of granting this particular use, given that it's not inconsistent with what had been existing, and
Not granting the use, affirming the use.
affirming the use.
Yeah.
Affirming the use. That's key, because it is an affirmation, and because, looking back, there are tons of folks who, failed to comply with what they'd agreed to, but it doesn't mean the next person up and the next developer is going to be consistent in that regard. So I think based on what's before us and the testimony that's been presented, I think this would be appropriate for approval.
Based on your statements, I agree. And I also commend the planning department for including this provision and including it in the future, we hope.
I agree as well.
I'd also like to add that the property is, considering the parking concerns, the property is located right across the street from MTA Yellow Link transit line, which connects very shortly to Mondawmin Mall to the transit hub. So considering that it is not a guarantee that all the prospective tenants will be driving, it's very possible that they can take public transportation. It's accessible to them also.
Good point.
I agree as well.
Okay.
May I simply ask a process question Thanks. Okay. So I really appreciate trying to understand what the board is doing versus what the zoning administrator is doing. This is incredibly helpful to me. So if the previous code had this part about vacancy, if a building goes into vacancy, then it sort of resets as single family, and now that's gone because of the 2017 change. To whom would we address our concerns so that we are not simply affirming uses that may have been legal in the 1950s when Baltimore looked very different, and we're not trying to go back to the 1950s?
So if you have an issue with the way that the code is written or the way that we have interpreted the code, certainly the city council can clarify that at any point on their own. You know, they write the code and we do our best to interpret the code the way that it's written. And sometimes there's ambiguities or confusion, and the city council can clarify that at any point. The only other thing I would say is that it's not that we are affirming any use the way it used to be from the 1950s, but multifamily use is a permitted use in this district. So if it were a non-conforming use, it wouldn't be allowed to continue, but because it is a permitted use, that is why, one of the reasons why it is allowed to continue. But yeah, certainly if the city council feels like we are interpreting things incorrectly, they can at any point update the code to be more clear about their intention for how we should interpret it.
Okay, and thank you very much. Right, we're not opposed to multifamily. The density is our concern, so thank you very much.
Thank you, ma'am. Okay, so we have that though. Thank you.
Thank you very much.
Final case on the docket, case number 2022-278, 2212 Essex Street. Adam Carballo is the appellant, and this is a request to construct a fourth floor penthouse addition. Is that correct?
That is correct.
Okay. I'll hear from staff and planning.
Okay, so the one conditional use that I have on this is to maximum building height. 35 feet is allowed, 45 feet, I believe, is proposed. So it would be one of those weird height conditional uses. They're very weird. I believe that is the only thing that's being requested here. The reason that this is on the contested docket is that we got a letter this morning saying that someone was opposed. So basically, let me just read this really quickly. This person lives next door. They have questions about the application. They said that the variance, well, it's not a variance, it's a conditional use, but it would require construction on our property line, and they would need to access our property at some point to complete the work. And I think that's basically the main issue that they had. So I'll leave it there.
Planning Department has no comment on this application. Thank you.
Thank you, Mr. French. Mr. Caballo.
Well, thank you for that introduction. Again, this is a weird conditional use for a fourth floor. As per the R8 zoning code, 35 feet is allowed as a matter of right. 45 feet, as it says verbatim here, a height higher than 35 feet up to a maximum of 45 feet, may only be allowed by the zoning board as a conditional use for a row house located on an interior lot that adjoins a street right-of-way of at least 30 feet wide. It goes on to say a row house located on a corner lot, but that's not applicable here. This is an interior lot. We meet the letter of the law of the code. Essex Street has a right-of-way of greater than 30 feet. We're not requesting anything greater than 45 feet. I'll also remind, on Essex Street, 2212 is our subject property. The board granted the same exact variance or conditional use for 2208 earlier this year. We are simply adding the same project to the adjoining neighbor. We have letters of support from other adjoining neighbors. There was a gentleman that was here who signed in who had to leave, but he lives at the end of the block. He's in here in support. We also presented to the Canton Community Association via a public meeting. We received a letter of support with unanimous support. This other adjoining neighbor is aware of the project, has been in touch with the homeowners. They're very aware of what the project is. There may be some requirement for access. These properties were all built at the same time. They all have fourth floor dog houses, pop-ups that go up to their existing roof decks already as it is. So we would be increasing the height slightly higher than that to actually construct the room. Part of the issue with these homes that they're 3-story homes. They have a garage that's accessed from the rear alley, the shared alley. The entire first floor is a garage. The second floor is a living room, dining room, kitchen, which only allows for 2 bedrooms, 2 bathrooms on the 3rd floor. Families that have children, they need more than 2 bedrooms. So I'm getting a lot of these requests, not only on this street, but, and I've presented maybe half a dozen of these to this board in the last few years. It really comes down to just needing additional bedroom space. And we've also tried to be sensitive to the neighborhood. We've actually set this addition back from the front cornice line, so it's not too obstructive. So we're trying to present these additions with a sensitivity to the neighborhood, but we're also allowing families to stay in the city, which is the goal of the mayor and the city council, is to promote families to, put roots in the city and stay here. So this actually goes, a long way to retain families in the community. So that's
Thank you.
all I have to say.
Thank you, Mr. Cabral. Does anyone have any questions for Mr. Cabral? No. I also want to, just for the record, Ms. Witt, if you could confirm what our process is and what our rule is with regard to submission of letters in support or opposition.
Our rule is that documents need to be submitted 24 hours ahead of time. We have not been consistent in any way about enforcing that rule. And we need to do a better job of it, because submitting things, whether it's in favor or in opposition, at the last minute gets chaotic pretty quickly. So this particular email was submitted this morning at 9 a.m. I don't know if anyone is here in opposition for this case or not, but I just wanted to put it on the record. But yeah, I think going forward, I think we can be, I can be a lot more clear about what is allowed and what the time period is. But it's 24 hours ahead is the rule.
Mr. Caballo, you indicated that the author of that email was aware of the project. What is the basis for your knowledge that they've been aware of this project?
It's based upon a phone conversation we had with the homeowner about an hour and a half before the meeting.
Okay.
We were aware. My office was made aware that this email, was turned in.
Mm-hmm.
I then reached out to the homeowner and said, "We got this email," and he said, "I know it is. We've had many conversations about this. There is no surprise." And also, I will reiterate that we did meet with the Canton Community Association, which is the appropriate community body, and we had, unanimous support from that group. That letter of support, that email of support, was sent from Doug Kaufman well in advance of this of this hearing date, there is no surprise of what we're trying to do. And, you know, I'll also additionally state that Ms. Anya, who lives at 2208, she is, my homeowner client, Paul and Kim, they're trying to contract with the same contractor so that both of these can be constructed at the same time, so that there's minimal disruption to the neighborhood. They're also done sort of by the same hand, so it'll look more consistent. So we are taking some, in fact, you know, Anya actually delayed her construction to try to accommodate Paul and Kim's schedule so that we have minimal disruption to the neighborhood. So we're trying to be as sensitive as possible and as transparent as possible with the community and the neighborhood and so forth.
The need to access an adjoining property for purpose of the construction, is that fairly standard in this type of construction?
Anytime you work on a property line, that's pretty standard. And obviously, Baltimore, especially R8 zoning district, your row house, you're building a row house, any addition requires some degree of access to your neighbor's property. It's very standard. You could not build an addition onto a row house without that condition being present.
Good. All right. Thank you.
Thank you.
Any takers?
It fits the character of the neighborhood, and it does not cause an adverse effect on adjoining property owners or surrounding property owners.
I think if there's any wording we used in approving the same conditional use height request the first time for something on the similar street, is there a way we can, not that you can read it to us now, but then,
Well, it was probably on consent, so the consent resolutions are pretty bare bones.
it was, you said it was probably on consent? I do
Probably.
remember one similar to this with a woman who brought her children with her to the.
I can look it up and find it for you.
Okay, yeah, I mean, if there is anything, in as much as we want the fourth floor penthouses to all be similar, I'd rather us have the same resolution on them all be similar as well.
Anyway, I'm a yes.
I'm a yes.
I mean, yes.
Good job, Mr. Chairman.
Okay,
We adjourn?
sounds like
That concludes the docket for today.
Thank you.